Hello, everyone. The topic for the day is essential areas of employment law. Essentially, employment laws, we will be covering all the topics that is more or less prevalent around the globe. We will extensively take help and assistance from international labor organizations framework together for the course of this particular videos. So before we proceed with the laws, we need to understand what is an employment law. Now, employment laws, I'm sure most of you are aware of it, that as an employee, we have a lot of responsibilities and duties. But what about our rights? Who guards it? It is the law of the land provided to the employee from the government is the employment law. So, employment law covers many areas of law altogether uh, that are related to employees, not only employees, but also employers and employment contractors, and so on and so forth. So, employee in law includes both the central government or the federal government, as we go say, the state government, or should I say the provincial government that goes around it. So, ideally, an employees and employers has to follow both the dictum at will, both federal and the state, or the central and the provincial government, as the case might be. So, employment laws covers a broad range of areas that exist in a workplace. An experienced employment law or a worker compensation lawyer can assist an employee or an employer in the following areas: employment discrimination, very pertinent. Workplace harassment, definitely yes. And nowadays sexual harassment has been enforced. POXO has been enforced, and every companies and every legal entity, disability accommodation, people with special abilities, let's say disabilities, accommodation, how do we go around it? What kind of restroom do we provide? What are the accessibility options that has been there? The restrictive covenants and confidential agreements is one thing where we cannot, as an employee, would not be able to divulge the secrets, the trade secrets, the trade details of the employers elsewhere other than within their companies itself. So these needs to be understood. We have the severance agreement. Yes, severance agreement plays an important thing. Family and Medical Leave Act compliance, true to the things. What has been family has been properly defined by the government and further refined, perhaps maybe by the company itself. We have the unemployment benefits, which has been provided by the government at well. The wages and the hourly issues, which have been revised on an annual basis, if not an annual basis, definitely on a biannual basis altogether. So human resources policies and handbooks are the prerogatives of the company, and, which they need to fulfill based on the broad guidelines already stated by the government. And last but not the least would be the disciplinary and the termination. We talk about it. So, what is employment discrimination? Employment discrimination laws apply to procedural steps of employment. It includes the interviewing, hiring, and advertising. Promoting and terminating employees needs to be understood. Employment discrimination law states that an employer can discriminate. Absolutely can discriminate? No. Can never discriminate an employees or potential employees based on race, based on gender, based on age, based on ethnicity, the national origin, the disability, the physical abilities, or religious. Some jurisdictions have extended discrimination to particular sexual orientation. Now, this is what we call about the LGBTQ community, which is everything will notified around it. So, the sexual orientations cannot be a preference or cannot be a basis for any sort of discrimination as long as the employee can deliver result, proactively contribute towards the overall profitability of the organization. Remember these things. So, one, discrimination, we can discriminate on race, gender, age, national origin, ethnicity, disability, religion, or even sexual orientation. This is of vital. So, what are the rights as an employee? First and foremost thing is to fair compensation. Work for a stipulated number of hours. A minimum wages needs to be accredited or credited to your account. Right to a safe workplace. Probably no dangers, no peril should actually come to you when you are working. It should be a positively environment. It should be a safe environment. It should have all the parameters which makes the environment quite healthy and calming effect. So right to a safe workplace. Last but not the least is freedom from discrimination and definitely retaliation. Retaliation can be anything, be it physical or psychological issues as such. So how much do employees have to pay for a lawyer? Many a times it has been notified that the many employees have a hard time affording an employment lawyer because they do not have a job. They cannot afford a legal services. So how do we go across it? Many employers know this and exploit this also. So contingency means employee owns the attorney, nothing for the legal services. There are provisions where the lawyers can, if the cause is right, can fight a case pro bono altogether. Apart from it, you have certain contingency where the attorney makes a settlement for the or the judges on the employee. So how much do the employees have it? These needs to be taken for consideration altogether. Many employment law attorneys who are defending employees in employment law cases actually agree on the employer's case on an hourly basis. Remember, for the employer, it is always on the hourly basis or a flat fee depending upon the complexity of the cases. When the fees is flat, when the complexity of the case is absolutely missing, it is a very simple case. It's a black and white distilled methodology that goes around it. Only in the complex cases, we the lawyers are actually charging on an hour. So we'll talk about it as fundamentally what are the collective bargaining that can be goes around it. A social dialogue, probably mechanism ensuring that terms and condition of employments, that is the wages, the working hours, the number of leaves, the breaks, are negotiated and definitely upgraded or updated after certain interval in line with the evolving environment. One of the three major instruments of wealth distribution is to keep inequality in check, something which we need to maintain it. We need to have the parameter of respecting each individuals as a human being. So collective bargaining vis-a-vis privacy, we need to balance it out. Social security vis-a-vis the privacy, private and public health insurance needs to be understood. That taxation has to be very much distilled through or clearly be very transparent with each one of us. These needs to be understood. We'll talk about what makes a collective bargaining very, very effective. First and the foremost thing is to recognize it formally. The employer must have a private property over productive assets and profits. The workers have a private property over their labors, their intellectual abilities, their motivation, willingness. They should have a complete control over it. That should be the private property of an of the workers. The most private proper parties, remember, negotiation is only a vehicle to transfer and definitely not by force. It is by will that there might be changes in the assets profits vis-a-vis the labor or the intellectual abilities of an employee and employer. So the employer and the worker, the ENW, have an equal, unequal bargaining power, right? This needs to be understood time and again. That is corrected by giving collective bargaining precedences over individuals. So that is the thing where we have an overall impact altogether. A worker so wish that employers must submit their fair share of wealth, probably pay a fair wages and negotiate productivity improvement in return. Trade unions, on the other hand, would be talking around what? They will be talking about having a trust and measure of control all to the workers. Understand the law, the legal boundaries within which the negotiation has to work around it. Understand the requirement of compromise. Yes, not every time it is a win-win situation, not every time it is a lose-lose situation. At times it needs to be some win, some lose kind of situation. Hence the emphasis. What are the emphasis? On the independence of the organization, on the entity altogether, on networking of the organization, right to join the federations or the confederations, on elections of the officer. There has to be a free transparency prevalent out there. Government must resist the temptation of coming to the rescue of either party. They should play the neutral role altogether, probably focused on the public interest dimensions only. So, what do they do about it? So, they have to protect any sort of violence. Avoid violence first. No compulsory arbitration. They should not take a side. They should not force one side to be subdued by the other, except when services affecting life and health of the people are at stake. Protect economic fallout, very true, of excessively protracted strikes, imposing on minimum operational requirement of public utility. When I say public utility, let's say the transport is a public utility, probably the energy is a public utility, and so on and so forth. Imposed or minimum safety requirement for a company. Yes, true, definitely, yes, this is a requirement for the human beings to work around in a humane can condition. Respect the bargaining of an autonomy. Labor inspectors are recommended not to get involved, or probably in conciliations or mediation process altogether. That needs to be understood. Careful, every strikes, please understand, every strikes that affect the bargaining balance of the party, this should not be encouraged. At the same time, the government has to balance, uh, maintain a balance between an employer and determine the status of the collective agreement of the relation of an individual employment contract. Government organizing swift, inexpensive, professional, informed right dispute settlement upholding laws is public function. Essential to private strikes over rights and dispute comes generally, remember, comes generally in terms of labor inspection and labor codes. So what we are going to do around it? We did I say at the very beginning of this particular video, we will be borrowing heavily from international labor standards. So exactly is all about it. We will be talking about ILO Constitution. When did it form? 1919. Declaration was in 1944. This is all mostly academic in nature. This particular slide goes slowly and steadily. Probably academic. There are standards, labor standards, and the faction, the rule books which has been mentioned out here in terms of industrial relationship, in terms of dispute settlement, in terms of consultation, the in terms of industrial relation provisions altogether about employment policies and labor inspection, which we have already discussed in my previous slide. If you have missed it, please watch this video once more. It will be very clear to you. These are the remnants from the ILO works altogether. Everything has been mentioned out here as to workers' representation, how to go around it for collective bargaining, workers' organization convention that we goes in 1975, how to go about it, the tripartite consultations, which means the government, the employers, and the employees that we are looking at it. These tripartite consultation, how to manage it, labor administration, the labor relations. Remember, labor relation is the crux for international labor organization for to come into existence. The collective bargaining we are talking about it. Last but not the least is the termination. Termination is one of the vices that an employment has to face always, probably, and so we'll talk about the collective agreement recommendation way back in 1951. What are the voluntary conciliations that comes into play? cooperative and legal laws. So, why am I recounting this International Labour Organization remnant or the rules altogether for every paragraph to you? Because from there onwards itself has been borrowed by the federal government, the state government have formed their bylaws, and the companies have to enact upon it. It gives you a general condition, and remember to apply it in cases of your company that you are working around. Communication within an undertaking is recommendations. And what you talk about, how do you handle grievances? Grievances is a must thing that needs to be addressed at the right time. If you delay grievances handling, if you delay it, you are further escalating the problem for yourself and the company at large. So this delay should be avoided altogether. The process needs to be phased out. We'll talk about the building blocks of typical legislative frameworks for a collective labor relation. Do we go out it? First and the foremost, we'll talk about the why, the reasons are about the purpose for it of collective labor. First and foremost is the dignity. Human dignity needs to be safeguarded. Human dignity needs to be respected. The freedom, the social justice, the harmonious relations among the laborers, the fair sharing of wealth between the employers and the employees, and in respect to the employees, the scale of delivery, the level of employment, the complexity of their duties that needs to be taken accounted for. Promoting workplace democracy is a must thing. Balancing labor market flexibility and security, we should always try to balance it, because any imbalance out there is to keep or the society at a loop, and the society will start malfunctioning, which is not a prudent thing in the first place. So commonly expressing legal guarantees that the organization for the workers, for the employers can be properly represent their members. That means they can be on a certain instruction, all the members and the functions in each other's position altogether, which tends to fluctuate with market condition. Now, the second option is to trade unions and employers organization. Establishment of an organization, trade unions, organization for workers, for the business associate, for the employees associations. We talked about it. How do we go for procedures of registration of organization? With the authority, submission of constitution, the bylaws that we keep on talking around it, how do we enact it, how do we guarantee the democratic functioning, that needs to be understood. Limited rules on financial transparency towards the organization members, not necessarily authorities or employees, to confirm the legal status as the binding outcomes of collective bargaining, the binding outcome of collective interest dispute procedure. Some rules, remember, some rules on validity, some rules about the scope of the project needs to be adhered to. Legally binding characters for collective agreement, both in terms of public and in terms of private contract, even if it is from person to person, even if the company is wholly owned, it should be working within the framework of the society. It should not entangle itself into certain illegal activities or illegal means or illegal provisions. So we need to understand this legal binding characters of collective agreements, bargaining. Fourth is the workplace cooperation mechanism, providing a regular sharing of information between the employers, between the unions. There should be a transparency altogether. It should be democratic in nature. The settlement, if there are any dispute that happens around the enterprise level, these employers, these unions should come to the table, talk it out, resolve their differences. No authority to engage in collective bargaining nor conclude collective agreement at all. So, collective bargaining, the choice for enterprise level bargaining is rules to determine bargaining rights needs to be understood. What are the rights that a person has? Choice for sector level or multi-employer bargaining, institutional framework. Now we are talking about several industries at all. Several industries would have a different parameters as far as bargaining is concerned. This council, this regulatory authority will take into consideration. So we have to have a good faith for each other's, trust one another, So have to come out with a positive outcome. Some definition of unfair labor practices typically involve discriminations, interference and behaviors by the employer, which is not to be encouraged. Now we come to the most potent thing of strike. Strike should not happen. Remember, collective bargaining minus the right to strike is all about becoming a beggar. Better thing is to talk it out, discuss your all your pros and cons. If you go on to strike, if you say it is my way or the highway, the other party can also come to those knees. Probably we are following or coming to a state of a stalemate altogether, and it leads to nothing else but collective bargaining. Peaceful strike action should be legitimized. Beyond collective bargaining, protest strike against changes to a minimum wage in the system, where the minimum wage is exclusively determined by the authorities, or let's say the government actually state you that how many dollars a day that you want to earn to maintain your cola is cost of living allowances, so that you have a decent life, you lead decently, the society functions properly altogether. Strike actions may be subject to procedures. What are the procedures? You need to give a notice. You need to give a shot at arbitration. You need to go for a conciliation before you actually send a notice and decide to go on a strike. Strike action may subject to certain limitation, aim to protect life and safety. Probably yes. And a population at a large, this needs to be understood. Essential services, minimum safety operation in public and private sector, minimum operational requirement in public utilities not considered essential as public transport, but probably for hospital you cannot go for a prolonged strike in a hospital, because there we are treating people who are maybe terminally ill or who are fragile in their health. So we need to understand the ILO fundamental governing convention, which is this itself, which tells you altogether about way back in 1930. Remember, forced labors with 175 ramification could have taken places. Remember, we're talking about 183 member states that have already participated, accredited, recognized, accepted this thing. 1948, probably number 87, freedom of association for the officer level, for the managers level, for the employers level, protection of the right to organize, ramification been 150. 1949 similarly was the right to organize collective bargaining. 49 is from where we actually bent out upon it. We are talking about equal employment opportunities way back in 1951, when this equal remuneration was given. Ramification 1 for 168. 1957, abolition of forced labor. Now the labor is always at will. You cannot force a labor to work under you. A human dignity has to be recognized. Discrimination or employment occupation, 1958. 1973 is the minimum age that we have stated out. Certain companies say, certain countries say 16 is the minimum age, certain countries say 18 is the minimum age. Probably nobody says below 16 as a minimum age of working around it. And worst form of child labor is presently the last thing that was done in 1999, with 174 ramification of the child labor. If you have understood this whole pathway, the growth that we have come across from 1930 to presently this 2022, these are the fundamental convention that I've tried to highlight it to you for your understanding. I come to an end of this particular video. Thank you for watching my video.